This is so nice to be here. I mean, I just love coming to Green Mountain Academy, and it's so nice to see so many familiar faces here. One of the things I like, other than the fact that this is such a smart audience, and you actually pay attention, you know you're not going to be taking an exam afterward, which means that you can relax and actually pay attention instead of, right, doing this or on the laptop. Yeah, so it's great to be here. You know, it's Constitution Week. How many of you knew it was Constitution Week? Well, when I worked a short time for Chief Justice Warren Burger. He, by the way, resigned shortly after he hired me, so. But he actually retired from the court in order to chair the commission on the bicentennial of the Constitution. And one of the things he was really devoted to was ensuring that the schools taught about the Constitution. And I'm told that today in grammar schools and in high schools, there is actually much more that's required of the students to learn about the Constitution. One of the other things that he wanted to do was to create a day in which the country would commemorate the Constitution. And in fact, it's a federal regulation that any educational institution that receives federal funds must set aside at least one day during this Constitution Week to do something commemorating or celebrating the Constitution. Well, in my school at Albany Law School, it always falls upon me to do it. You see, in academia, I mean, being a patriot is either quaint or suspect or worse. But I'm a proud veteran, and so they usually give it to me. And so we have a celebration. We actually had a celebration at noon. I mean, a real celebration where we had singing, we had some patriotic stuff. We even had an impersonator that came in, and he did Bill Clinton, he did George W. Bush, and he did the Donald, and he was absolutely fabulous. And then, of course, we had the food, because that's the way you get the students to come, right? You have food and you have beverages. But earlier in the day, we had a serious event where myself and another constitutional law professor spoke about our choices of the best and the worst Supreme Court constitutional decisions. And I was thinking, it was fabulous, I mean, this guy's fabulous, Steve Clark. I was thinking maybe next year we ought to do one, the best and the worst Supreme Court justices. And about our topic today, I think it is pretty clear already that in the minds of many people, if not by this point, pretty soon, he will be considered either one of the best or one of the worst, because I think his views will certainly be very polarizing. So let's talk about now Justice Neil Gorsuch. And he has a record. He has a record before he got to the United States Supreme Court, because he was an appellate judge on the Federal Appeals Court. And, you know, although with regard to Neil Gorsuch, as is the case with virtually every nominee to the United States Supreme Court, the president and the president's party insist that the nominee is a centrist, that he's a moderate. He's not an activist. He's just going to apply the law. Well, you know, usually that's a lot of nonsense. It's a lot of nonsense. And it certainly isn't only Republican presidents. I mean, the Democratic presidents do the same thing. I mean, when Barack Obama and his administration were insisting that Sonia Sotomayor was just a centrist, a moderate, I mean, that was nonsense. I mean, anybody that actually looked at her record knew that she was going to be extremely liberal. And I'm talking about in the political sense, extremely liberal. That was her record on the Federal Appeals Court, and it certainly is her record on the United States Supreme Court. In fact, she probably is the most liberal, politically liberal member of the court, even more so than Ruth Bader Ginsburg. Well, Neil Gorsuch has a record. and his record on the Federal Appeals Court was very distinctive. He already has a record on the United States Supreme Court, even though he has only sat on the court for about 2.5 months worth of cases. But his record on the United States Supreme Court is already distinctive. So we're going to look at his appellate past. We're also going to look at what he's done already on the United States Supreme Court. So we'll talk a little bit about the Scalia vacancy, what happened with that. That was in the news, so many of you are familiar with that. We're going to talk about Gorsuch as a nominee. That is, what he has said about his judicial philosophy. You know, if there's one thing you can say about Gorsuch, and you could say it about Scalia and some other justices, you could have said it about Chief Justice William Rehnquist, that they actually articulate a judicial philosophy. They articulate their view of the judicial role and how they think judges ought to decide cases. Now, caveat, that's not necessarily how they actually decide cases, but they have a theory as to how judges ought to go about deciding cases, and they become real devotees of that particular philosophy. Gorsuch is one of them, and he follows Scalia, who is certainly one of them. But he has a judicial philosophy. He's also got a circuit court record. And on the United States Supreme Court, as I've said, he already has a record. Here are the justices as of January 2016. I won't presume that you know the names of all of them, but this is, of course, is the Chief Justice, John Roberts, right? This is Antonin Scalia, the one that passed away the following month, right? This is Anthony Kennedy. We all know him as the swing vote on the court. I call him the only one that acts like a judge. And then we have Clarence Thomas, Ruth Bader Ginsburg, Stephen Breyer, Samuel Alito, Sonia Sotomayor, and Elena Kagan. Well, again, the next month, Antonin Scalia had passed away. So when the term began, this very past term began, and terms begin in October, the first Monday in October, this is what the court looked like. I mean, it was an 8-member court. Obama, of course, nominated Merrick Garland, but that nomination never got anywhere. Merrick Garland actually would have been somewhat close to Anthony Kennedy. I think he would have been kind of in the center of the court, but like Anthony Kennedy is a little bit to the right of center. I believe that Merrick Garland, from his record, would have been a little bit left of center. But still, I think he would not have been anywhere near as ideological as some of the liberals like Ginsburg or Sotomayor, or the conservatives such as Thomas and Scalia was and Alito is. Well, that went down. Donald Trump was elected, and he was insisting that he was going to nominate somebody just like Scalia. I'll let you in on a secret. Donald Trump probably hasn't a clue what Scalia was like, right? But there were individuals who were advising him who certainly knew what Scalia was like, much more so than the public knew what Scalia was like. And that was the Federalist Society and the Heritage Foundation, two conservative organizations, very smart, very bright, very knowledgeable, and they knew what Scalia was like, and they wanted somebody like Scalia. And in fact, it was one way they figured that Trump could prove himself to be a conservative. Nominate somebody like Scalia, then we'll believe you're a conservative. Or even if we don't believe you, at least we'll get a justice out of you that we like. And so he was insisting he was going to appoint somebody just like Scalia, because Scalia was the greatest justice ever, and I'm sure he knew nothing about that. But, and that's not just Donald Trump. I mean, at least half the presidents, probably more than that, probably don't have a clue. They probably don't have a clue. So they're told that this justice is conservative, or this justice is liberal, or what is the litmus test today? The all-important litmus test today, do you like Roe v. Wade or don't you like Roe v. Wade, right? That's almost like the judicial sacrament, Roe versus Wade. So anyway, so Trump nominates Gorsuch, and Gorsuch is confirmed. And here's the court. Here's the current court. So Gorsuch has taken his place. Now, for the background of Gorsuch, this is the record of the court for the last 2 terms in which there was a full complement of 9 justices on the court. And you can see there's a huge difference between these 4 and those 4. And I have to caution you that these 2 years, for whatever reasons, there was a collection of cases at the court that actually brought the court toward the more liberal side. They were the cases where it was a little more obvious the liberals were going to win. So actually the difference, the traditional difference over the last decade or 2 is actually much more stark than this. But you can see, here are the Democratic appointees, here are the Republican appointees, and here's Kennedy. So he is the swing vote. He is the swing vote. And when I talk about politically liberal, I'm not talking about judicial philosophy. I'm talking about there's an issue in the case. How would you expect a Republican politician to vote? How would you expect a Democratic politician to vote? I'm not talking about judicial restraint. I'm not talking about strict construction. I'm not talking about originalism, textualism, or any of that other stuff. I'm talking about political ideology. And that's the way they line up. The Democrats, they vote on the court like Democratic politicians. The Republicans on the court vote like Republican politicians, and Kennedy is about 50-50. That's just the flip side, right? That's politically conservative. Now, if we add to that, the year in which Scalia was on the court for at least half the term, and then passed away, and we include those cases where the court either split very deeply, or the court split evenly 4-4 because there were only 8 members on the court. And we know darn well that when the court split 4-4, they don't tell us how the justices vote, but we know darn well, because of the issues, that it must have been the 4 Democrats on one side and the 4 Republicans on the other side. The court splits, so it doesn't decide the case. It doesn't decide the case. Well, if we include all those and say, well, we know how Scalia was going to vote in those cases. How do we know? Because he basically signaled how he was going to vote in those cases. Same thing. Look at that. Look at that. All righty. So Trump's first appointee. What do we know about him? Well, he clerked for Justice Byron White. Byron White, who was a John Kennedy appointee. Byron White, very interestingly, is one of the exceptions to the rule. That is, most of the justices on the court, if they change ideologically, if there's a transformation, they almost always go from being more conservative to more liberal, which is one of the reasons why conservative Republicans are usually so frustrated, because a Republican president will put a justice on the court, and then over time, that justice becomes much more liberal. And as I always say, that either means the justice is getting smarter or the justice is getting more senile, one or the other, right? But they always change. They almost always turn. Justice White turned in the opposite direction, appointed by John Kennedy, but by the latter part of his tenure on the Supreme Court, he was voting much more frequently with the conservatives than he was with the liberals. Justice White retired, so he recommended that Gorsuch work with Kennedy, Anthony Kennedy. They worked something out. Interesting that Gorsuch worked with Justice Kennedy. The word is that Gorsuch, as a law clerk, for Anthony Kennedy had very, very different views. They didn't necessarily see eye to eye. In fact, it's a sure thing. It's a sure thing. Gorsuch did not see eye to eye with Kennedy about such things as gay rights, lesbian rights, same-sex marriage, and those kinds of things. He certainly did not view him that way. Anyway, he had been appointed by George W. Bush to the Federal Appeals Court, conservative Republican. He's only 49 years old. 49 years old, what does that mean? They stay on the United States Supreme Court for a long, long time. It's not like most other courts in the country, state courts, where there's a limited term or there's a mandatory retirement at a certain age. They can stay on interminably. So if he's like the average justice over the past decade or two, he's going to be on the court for over 30 years. All right. There were some studies done by political scientists and law professors before Gorsuch was even nominated, right? So these weren't studies that had the motivation of making them look bad, right, or good. These were studies of how all the federal judges voted and how their votes compared to one another. Neil Gorsuch was deemed to be one of the most conservative, politically conservative judges on the federal bench, even before he was nominated. And that was from the University of Chicago, a University of Chicago study. Here's a study by Lee Epstein, one of the foremost political scientists in the country. And after he was nominated, she looks at his record and says, what will he be like on the United States Supreme Court? She said that he would be more conservative than Scalia, but perhaps not as conservative as Clarence Thomas, but certainly one of the most politically conservative justices on the court. There was another study that was done, and they figured that Gorsuch, in accord with his record on the Federal Appeals Court, would be the most conservative justice on the United States Supreme Court, even more so than Clarence Thomas. Okay. Whichever one of these studies was more accurate, the point is that every study points to the fact that this is going to be an extremely politically conservative justice. That might be good, that might be bad, but he's going to be politically conservative. All right. What do we know about him? He idolized Scalia. That should tell you something. That should tell you something because we know what Scalia's record was. Scalia's record was extremely politically conservative. Again, that doesn't necessarily mean good or bad, wise or foolish. It was just extremely politically conservative. Scalia was his hero. And Gorsuch professes to be like Scalia. This is the way I decide cases. I look at what those words in the Constitution originally meant. That's what he says. That's what he says. He and Scalia say that's the way they decide cases and how judges ought to decide cases. You look to whatever the writing is and you say what those words meant at the time they were written. So in the Constitution, you'd look back to 1787 with regard to the 14th Amendment, which is extremely important because that made federal constitutional rights applicable to the states. That was in 1868. Just think of how the values and what was being thought by the drafters in 1787 and in 1868, how those values differed from our own, right? And especially with regard to women's rights, LGBT rights, unenumerated rights, religion and the law, the role of the courts. Okay. When Justice Scalia passed away, this is what Gorsuch said. This is what he wrote. He gave a talk, and then he turned that talk into a law review article. He was skiing. There's a man crying. He says he could barely see. This is his idol. This is really his idol, Scalia. And here he says, he embraces Scalia's view of how judges ought to interpret the Constitution. Judges should apply the law as it is, focusing backward, not forward. Just think of that. Again, wise or foolish, right or wrong. He's saying judges ought not to be looking forward. They ought to be focusing backward. At the time, these words were written. That has some really serious consequences. And again, he says the founders, right? He's going back to the founders, understood judicial power as a very different kind of power than legislative power. It's not forward-looking. So, you know, when some of us, myself certainly included, say, well, we want the judges to make the Constitution a living Constitution. So, for example, equal protection means something different today than it certainly meant in 1868. Right? I mean, they certainly didn't mean for women to have equal rights in 1868. It never would have been passed. They certainly didn't mean for gays and lesbians to have equal rights. It never would have passed if they told the voters that. And he's saying, no, it's not forward-looking, but backward-looking. Differences between judges and legislators. He says legislators look to social utility. Judges should do none of these things. There is literally a debate among judges and some scholars. There's a debate as to whether or not justices and judges generally ought to even consider the consequences of their decisions. Some, like Scalia and Gorsuch, this is at least what they're advocating. I'm not telling you this is actually how they decide cases. But what they advocate, and they say judges ought to be doing, is simply applying whatever the heck the law says, what those words meant at the time they were written, regardless of the consequences. Well, suppose the consequence is absurd. That's too bad. Then the Constitution should be amended, or the legislature ought to amend the statute. All right? We're not here to decide what the consequences ought to be, regardless of how outrageous the consequences might be. Right? There's the other view, which is much more customary, which is, well, of course judges consider the consequences. But he says, no, judges should not be doing any of those things. It's not for the judge to decide based on policy consequences. And of course, this is what the justices, the nominees usually say before the nominating commission, the senatorial nomination commission. Let me let you in on a secret. These are not constitutional scholars or judicial scholars that are in the Senate on the Judiciary Committee. I mean, they're politicians, right? They probably have staff, well, they almost certainly, some of them have staff members who know their stuff, but they don't. And in fact, so much of what they say, the politicians at these hearings, are just nonsense. They're just absolutely nonsense. And that's not liberal or conservative. I mean, it's just nonsense. They just don't know what they're talking about. But what the nominees always say is, I will not make any law. Judges should not make any law. We just take the facts and we just apply the law to the facts and we get the result. Well, of course you can't do that. You can't do that because by the time the case gets to the United States Supreme Court, or by the time it gets to the Vermont Supreme Court, or the New York Court of Appeals, that's our high court, or the California Supreme Court, the cases are there because there isn't any clear law. Or because if you look at this law, it will lead you one way. If you look at this law, it leads you another way. The judges have to decide the cases, and when they decide the cases, they make law. It's that simple, which is why, of course, in law school, what do we read? Cases and decisions, because that's the law. But, you know, you don't say that. You don't say that before the Senate, because they don't want to hear that judges make law. All right, let's compare Gorsuch to Oliver Wendell Holmes, one of the greats. If you would ask any constitutional scholar, constitutional historian, okay, the top 10 justices, even judges in the history of the United States, Holmes is always up there. He's in the top 5. All right, what does he say? Say, yeah, judges write as though their decisions are purely logical. But he says, behind that logical form lies a judgment. My word, can you imagine judges should actually exercise judgment. If you're nominated to the Supreme Court, don't tell the politicians that, because you won't get through. But he says with regard to the judgment, often and inarticulate, and by that he doesn't mean it's clumsily worded, he just means that they never say it, they never put it in words what their actual judgment is. And sometimes unconscious, like they don't even know that's what they're doing. And yet it's the very root and nerve of the entire case. It is because of some belief or because of some opinion as to policy. Ooh, he'd never get through. He wouldn't get through today. Then he says, the duty of weighing considerations of social advantage. He says, the judges have a duty to consider the consequences, to see what makes sense and what does not make sense. What's good for society, what isn't good for society. He says the duty is inevitable. They can't avoid it. And he says the result of the often proclaimed judicial aversion to deal with such we don't deal with those considerations, right? Is simply to leave the very ground and foundation of the judgment inarticulate and unconscious. They don't like to admit it, but he's saying that's what they're doing. And by refusing to admit that's what they're doing is to actually conceal the real reason why the judges or justices are voting a particular way. The interesting thing about that, however, is as Benjamin Cardozo, another one of the all-time greats, as he would say in his seminal work, The Nature of the Judicial Process, he said, you know, most of the time the judges don't like to admit the reason for which they're deciding cases. Oftentimes they're not even aware that's the reason why. But if you actually analyze their votes, you analyze their decisions, you connect the dots, and you can see what the actual bases are, what their actually beliefs are that are motivating their particular votes. But anyway, Benjamin Cardozo, another one, in everybody's top 10 of all time. I take judge-made law as one of the existing realities of life. He ain't getting through the Judiciary Committee. He says the judge must balance all the ingredients, philosophy, logic, analogies, history, customs, as wisely as the judge can. When a rule has been found to be inconsistent with the sense of justice or with social values, there should be full abandonment. The content of constitutional immunities is not constant. He's not an originalist. Not constant. Varies from age to age. The Constitution is about principles for an expanding future. My only point is, yes, I do believe with Holmes and Cardozo, and I think it's virtually impossible to deny that this is what judges are actually doing, even those who vociferously deny that what they're doing. But the point here is that what Gorsuch is saying judges ought to do, and what he's claiming he and Scalia have done, I think you need to take that with a grain of salt. No, with a truckload of salt. Now, it may be that you or I or someone else think, well, Gorsuch is going to be great. Why? Let's be honest about it. Well, because he's going to vote like a political conservative, and that's what I want. Fine. But it's certainly not because because he won't be making law. He's going to be making law. And he's going to be using his judgment. And he's going to be considering the policy consequences. Okay. Let's apply Gorsuch's jurisprudence to landmark cases. Oh, what is a landmark? Oh, a landmark case is a decision of a court where they didn't look backward, where they actually looked forward, where they didn't simply apply what the court had been applying in the past over and over and over again. And in every one of these cases, the court rejected the past and it went forward. Brown versus Board of Education, prohibiting racial segregation. The 14th Amendment, equal protection, never would have been ratified. Never would have been ratified if the states were told, this is going to mean that your white daughter is going to have to go to school with a black kid. It never would have happened. Never would have happened. But the United States Supreme Court in Brown versus Board of Education said, this is terribly wrong, this segregation. We have to end it. They looked forward. What would he have done with that? I'm pretty darn sure what he would have done. He would have voted the other way. He would have voted the other way. Women's rights, Reed v. Reed. You know that the United States Supreme Court did not decide that women were entitled to equal protection under the Constitution until 1971, which is usually a shock to my students. 1971. Why? Because that's not what the Equal Protection Clause meant at the time. Scalia and Gorsuch, not what it meant at the time. In fact, Scalia always insisted till the end, equal protection did not apply to women. So that wouldn't have happened, looking backward. Gay rights, forget about that one. Interracial marriage, forget about that one. The civil rights laws, no, because the United States Supreme Court actually, very shortly after the 14th Amendment, Equal Protection Clause, was ratified in 1868, very shortly thereafter, actually invalidated the civil rights laws. They invalidated them in a series of cases. And it wasn't until 1964, Attorney General Bobby Kennedy, right, came up with a different theory. He tried that on the United States Supreme Court. They were ready to uphold civil rights laws, and they upheld it. They were looking forward. Birth control, forget it. 1960, same-sex marriage, forget it. Right to counsel. Gideon versus Wainwright. An accused is entitled to counsel in a criminal case. Not only that, but if the accused is poor, the government will provide the accused with an attorney. Because as Benjamin Cardozo would say at Polko versus Connecticut in 1932, he said you can't have a fair trial if you have a defendant that doesn't have an attorney. First of all, there's nothing in the United States Constitution that says that poor people are entitled to government providing them with an attorney. And this was a landmark decision because it changed the law. Katz, expectation of privacy. The Fourth Amendment search and seizure rights don't only protect those items that are mentioned in the Fourth Amendment, but the Fourth Amendment search and seizure rights protect our legitimate expectations of privacy. What they did there in 1967, they actually adopted Louis Brandeis' dissent from a 1928 case in which Louis Brandeis said, well, of course the Fourth Amendment shouldn't just simply be about those particular things that were mentioned in the Fourth Amendment. It should be about protecting people's private spheres. Self-incrimination, rejected repeatedly as a right that the states had to honor. 64, that was changed. Double jeopardy, rejected repeatedly until 1969. Reasonable doubt, I bet you didn't know this one. The standard that the prosecution had to prove guilt beyond a reasonable doubt, Supreme Court finally got around to saying, yeah, that's required in 1970. Those are the bad old days when you had a liberal court. Of course, virtually all these things we've looked at, if you were to ask somebody, what is it that you love about being an American? What do you cherish about being an American? It would be most of these things, or many of these things, right? And that didn't happen. Virtually all these things happened in the 60s and some in the 70s. Reasonable doubt 70. The right to testify. Do you know a defendant didn't even have a federal constitutional right to testify on his own behalf until 1987? Yeah. That's right. Make that look, because that's absolutely. Who knew that? Because we take all this for granted now. We take it all for granted. Looking backward, not forward, what would happen to any of those? All right, his circuit court record. Now his actual record. Let's see what he did when he actually had to vote, as opposed to just philosophizing about what judges should do. Some of this we heard from the Democratic politicians in the Senate Judiciary Committee, some of which, but they weren't too much better informed than the Republicans were on the Senate Judiciary Committee. They kept harping on that one worker rights case. Believe me, there were plenty of them. but they apparently could only come up with one. Anyway, women's rights. Planned Parenthood. Well, the governor of Utah decided to defund Planned Parenthood, and apparently he came up with reasons that the rest of the federal appeals court were nonsense. He was apparently, what should I say? I could say pandering to his base, but I guess he was doing what his base wanted, and he decided that Utah was not going to fund Planned Parenthood. The appellate court said, your reasons are ridiculous. These are not legitimate reasons. Gorsuch took the time to write a dissent and say, no, the governor can defund Planned Parenthood. Okay, look, you could have different views on these things. Fine. But over a long period of time, connect the dots. Then there's the Hobby Lobby case. That has to do with mandatory birth control coverage, right? And he was on the side that Obamacare could not require mandatory birth control coverage. Religion and the law. Religion and the law. It's pretty clear if you've heard Gorsuch talk that he's certainly a traditional religionist, an old-fashioned religionist. So American Atheist versus Davenport. Well, the town decided to put 12-foot high white crosses along the road in their town. It gets to the circuit court, and the circuit court says, wait a minute, that violates non-establishment. You are endorsing Christianity. You're promoting Christianity. That's what the court said. Gorsuch writes a dissent saying the town is not promoting or endorsing Christianity. And no reasonable observer could think that the town was doing that by erecting 12-foot crosses. Well, what did he think they were doing? So you know that's not really why. He might actually believe that the non-establishment principle ought not to prevent government from endorsing or promoting religion. In fact, I am absolutely sure that he thinks it's fine for government to promote and endorse religion, even if it's one religion, Christianity. Certainly Scalia thought that. But, what does he can't say that because that's not the law. So what does he say? Well, this isn't endorsing or promoting Christianity. I don't know. And then, let's see, the town wanted to put the Ten Commandments on the courthouse lawn. The court said no. And then he took the dissent, saying, they're only doing it for historical reasons, not for religious reasons. Okay, they don't fight for the Ten Commandments because of history. They fight for the Ten Commandments because of religion. So it's hard to imagine he really believes what he's writing, but what is true if you connect the dots, he'd like to lower the wall of separation between church and state. That's arguable, but that's not what he's saying. Workers' rights. Okay, here's that case where you had the truck driver was going to freeze to death. The rig breaks, the truck driver is going to freeze to death, so the truck driver disconnects the rig and he drives into town. The company fires him. So the circuit court, the appellate court says, you cannot fire a worker who's doing what he has to do to save his own life. He dissents. And he says it's not in the contract that he's allowed to leave his rig. Okay, so the Democrats really harped on that one. But there were others. And you connect the dots and you see. He's apparently hostile to workers' rights. Or, put it in a nice way, he's very, very pro-business. The NLRB case. Certain workers were fighting for their back pay. And the circuit court said, you can't, they're entitled to back pay and you can't retroactively reduce it. He dissents and says, yes, they should be allowed to reduce the back pay. I'm sure there was an argument on both sides, but again, connect the dots. The Flinton case. An attorney representing the worker was successful, and under the law, successful attorneys representing workers are entitled to attorney's fees. You want to encourage attorneys to represent workers. The court says, well, of course. Gorsuch says, no, the attorney is not entitled to attorney's fees. Again, I'm sure there were arguments both ways. Connect the dots. Death penalty is another thing he apparently loves. Majority approved. Here was a juror who said at voir dire, that's when the judge and the attorneys are questioning the jurors, could you render a fair decision in this case? Well, yeah, but if he's guilty of murder, he should get the death penalty. But do you think you can consider life in prison? Well, to tell you the truth, I get emotional about this, and if he killed somebody, I think he ought to get the death penalty. Divided case, Gorsuch writes the opinion, this time for the majority, saying that it's perfectly okay for there to be this juror who strongly preferred the death penalty and apparently wasn't too willing to consider anything but the death penalty. Allen versus Workman. Here's another case where the circuit court said, we've got to stay the execution. We've got to stop the execution until we consider the questions in this case that have arisen. He writes a dissent. No stay. Let them be executed, even though there are issues. All right. What about on the Supreme Court thus far? On the Supreme Court thus far. Even though he's only been on the court for a short period of time, right? 2 months, 2.5 months. He's already been involved in some contentious cases. Not only that, but he has written in several of them, or cast a dissenting vote in several of them. So we know what he thinks is important. That's one of the best ways you could tell what a judge thinks is important. Look at the opinions this judge writes when the judge is writing a dissent. That is, when the judge is openly disagreeing with the colleagues. When the judge is saying to the public, my colleagues are wrong. In fact, they're so wrong. I'm a busy judge. I'm going to spend my time writing an opinion to show you that they're wrong. Okay? Death penalty, campaign finance. In fact, you probably could figure out how he's going to vote on these. You could probably figure out how he's going to vote. Death penalty, campaign finance, an indigent criminal, workers' rights, well, you know. Trump's travel ban, that's an church and state, you know. Gay rights, gun rights. Okay, death penalty. Arkansas, the state of Arkansas decides that they better execute 11 inmates before the lethal medication expires. It was about to expire in a week or two. So they decided, let's hurry this stuff up. Well, one of the inmates actually had petitioned for a writ of habeas corpus because there was reason to think that maybe this particular inmate was wrongfully convicted. He seeks a stay of execution, right? 5-4, just an order, right? Gorsuch joins the majority, let Arkansas execute him. Say, okay, again, there are issues, but again, add up all his votes. Campaign finance, well, you know, Republicans apparently hate restrictions on campaign finance. Democrats love restrictions on campaign finance, right? And forget about the merits. In this one, okay, part of the McCain-Feingold are restrictions that if an individual gives money to a PAC, gives money to some group that perhaps is going to create a political advertisement, that money cannot go to a political party or a political candidate because there still are restrictions on how much money you can give directly to a political candidate, because that starts to look like bribery. You start giving a political candidate $1 million, it starts to look like you're expecting something in return. So one of the restrictions is that if you give money in a way that's allowed under McCain-Feingold, that money cannot be then diverted to a political candidate. It cannot be diverted to a political party. That was one of the protections. 7-2. They didn't even bother signing it. Look at this. Republican John Roberts, Republican Kennedy, Republican Alito. These are all justices that always voted against campaign spending restrictions. They voted for Citizens United, right? To eliminate restrictions on campaign spending. And yet, even they said, well, this rule you have to have, it's perfectly fine. Gorsuch is with Thomas. Even that restriction's no good. Indigent criminal defense. Is a poor defendant entitled to have access to some mental health expert? If the defense is, I am incompetent or legally insane, is the poor individual who we know is entitled to an attorney, is he entitled to have some access to a mental health expert? Case is 5-4. It's hard to imagine why it's 5-4. But in any event, Gorsuch is with the dissent, saying that no, the poor person isn't entitled to any access, any access at all, to a mental health expert. Workers' rights. Okay, is this a surprise? Okay, here's a case, if you actually look at this case, unless you're somebody like me that's a total geek and loves to look at this stuff really closely and try to figure out what's going on, it would seem like a very, very technical issue. Like who cares? It's not one of these we care about, right? This is the question in the case. After a worker goes before an administrative board, this administrative board, and that administrative board rules against the worker is allowed to appeal to the courts. The question in the case, the technical question, does the worker appeal to the federal trial court, the district court, or does the worker appeal to the federal circuit court, the federal appellate court? So the federal district court, the federal circuit court. You say, well, that's kind of a technical question. If you look behind the technical question, what do you find? You find that if the worker gets to go to the federal trial court, the federal trial court hears the case brand new. The federal trial court hears all the merits of the case. If you go to the circuit court, their appellate court, that appellate court is bound to defer to the administrative ruling, unless the administrative ruling is totally irrational. So, if you want to help the worker, you say, yeah, you let him go to the district court. You say, the hell with the worker, you have him go to the circuit court. Oh, I wonder who voted that, I wonder who voted that the worker goes to the circuit court, which has to defer to the board, which ruled against the worker. So a technical case, you look deeper into it and you find out it's a case about workers' rights. All right, the Trump. Trump's executive order, banning refugees from Muslim-majority countries. The case gets up to the United States Supreme Court, and it was a little confusing the way it was reported, the result in the case. What the court did was actually, in most part, it affirmed the lower courts, which had invalidated Trump's executive order. It affirmed the invalidation of Trump's executive order, saying that no, Trump could not prevent these refugees coming from these majority Muslim countries, unless these refugees had absolutely no connection to the United States at all. Not any family connection, not any job connection, not any education connection, all right? So they, by and large, affirmed the lower courts, invalidating most of Trump's executive order. These three, you know they don't want to invalidate the whole thing just by looking at who they are. No, they even wanted to uphold Trump's executive order with regard to people who had close familiar relationships in the United States. So even grandmas, even children, they wanted to uphold Trump's executive order in its entirety. Again, maybe they're right. I'm just telling you what's the common thread here. Church and state separation. This one had to do with, this really is a fascinating case. We're starting to get lots of these cases. This case had to do with the great state of Missouri. The great state of Missouri, which apparently had, they had this program where they would provide funding to any organization that had a children's playground. They were providing funding specifically to redo the floor, the ground, to make it soft so the kids wouldn't get hurt. Well, Trinity Lutheran Church, they said, well, we'd like to apply for the funding. And Missouri said, no, because you're a church. Say, Missouri? Missouri is like against this Lutheran church? What's that about? Go back a bit to the late 1800s, the early 1900s. And what happens? You start getting some Jews and Catholics and other deplorables that were immigrating into the United States in large numbers, and some of them were landing in the South or landing in the Bible Belt. And so, in order to ensure that no money, even indirectly, was going to any Jewish institutions or Catholic institutions, many of these states passed these amendments, these state constitutional amendments, prohibiting any aid, any support whatsoever, direct or indirect, to religious institutions, meaning Jewish or Catholic, okay? Now, of course, these same states are the states that want to promote religion, endorse religion, but they're stuck with these amendments to their state constitutions. So Missouri said, under our state constitution, we can't allow it. We can't give you the funding. It gets to the United States Supreme Court, and the United States Supreme Court 522 says you can't discriminate against religion. In short, much of what those state constitutional amendments in the South and in the Bible Belt wanted to do is unconstitutional discrimination against religious organizations. In other words, if you have a neutral program, a secular program, it's not a religious one, it's a secular program, you have to treat religious institutions the same way you treat any other institutions. Sounds perfectly fine. You have Ginsburg and Sotomayor saying, no, we have never allowed direct funding to a church, because this is direct funding to a church. To which the Chief Justice replies, we're not giving money to the church for anything religious. This is to help the kids. That's why there can be no discrimination against the church, because it's simply for the secular reason of helping the children. Gorsuch and Thomas weren't happy with that. Gorsuch and Thomas weren't happy. They dissented from those remarks of, as my wife calls him, Johnny G. The Chief Justice dissented from those and says, we don't think that religious anti-discrimination is that limited. We don't think religious organizations and religion should be discriminated against at all, shouldn't be burdens on them at all. And what is he thinking, and what should you be thinking? The baker who doesn't want to provide a cake for gay or lesbian birthday party, or the caterer who doesn't want to provide his hall for same-sex marriage. That's what he's thinking about. We're pretty darn sure that's what he's thinking about. In fact, I guarantee you that's what he's thinking about. How do I know? Oh, there's this case. There's this case. This is a great one. They're all great. Okay, this one, per curiam. In other words, nobody signed it. This case, what happened in this case, Arkansas, again, one of the usual suspects. Arkansas decides that on the birth certificate for the child, where you have the two spouses, the names of the two spouses, they refuse to put the spouse who's a partner of the biological mother. So if it's a same-sex couple, they refuse to put both spouses on the birth certificate. They'll only put the biological mother on the birth certificate. So the case gets to the United States Supreme Court. Now remember, the case Obergefell was a deeply divided case. He voted against same-sex marriage. Okay, so he's added to the five. There was five, right? And well, yes, but I mean, he was on the other side in the Obergefell case, same-sex marriage case. He now joins the majority to say, Arkansas, you cannot discriminate against same-sex couples. We told you that in the Obergefell case. That's what the ruling was. So now even the Chief Justice is on board. Okay, 6-3. You know what Gorsuch writes? And it's like hard to believe that a serious judge or lawyer would think this. He says that the Obergefell case only said that same-sex couples could get married. It didn't say that they were entitled to the same benefits of marriage as other married couples. I mean, you can't take some of this seriously. If he were to say, I think that same-sex marriages are an abomination, I don't think they're good for society for this reason, that reason, this reason, that reason, you could say, well, I disagree or I agree with him, but that's probably what he really thinks. But don't tell me that the court says you can't discriminate against same-sex couples, they should be allowed to be married, but then say, but that decision didn't mean that they're entitled to marital benefits. So anyway, that's why I know between the religion cases and this case, that's how I'm pretty confident how he's going to vote on these cases involving service providers who don't want to provide the same-sex couple. All right, gun rights. Here's another one. You know how he's going to be, okay? He's a conservative partisan, right? He's a conservative political. Again, he may be totally right on all these things, but he's voting like a conservative political partisan. Gun rights. California says, in order to carry a concealed weapon in a public place, like a courthouse, a public school, you need to get a permit. You need to get a permit. The court summarily, it just says, we're not even going to bother hearing that case. Why bother hearing it? Gorsuch and Thomas saying, you're disparaging gun rights. We should hear that case. So apparently they didn't even like that one, that you have to get a permit to carry a concealed weapon in a public place. All right. Since he's been on the court, just in the cases in which he's participated, right? Just in the cases in which he's participated. Here's the court. Of course, you have Ginsburg, Sotomayor, Breyer, and Kagan. There was one case in which they voted with the conservatives. Gorsuch and Thomas, 0. They never voted on the side that a political liberal was. They never saw merit in any decision that a political liberal would reach. Alito, 32%. Look at this, Roberts. Roberts now, 50-50. With Gorsuch on the court, all of a sudden Roberts is 50-50. And Kennedy, of course, 59. That's just the flip side. All righty. Let's go past this so I can give you time for questions. Concluding observations. Okay, there's the court again. Going from liberal to conservative, Sotomayor, appointed by Obama. A wise Latina, remember that? And of course, they were so upset that she could say such a thing. Ginsburg, appointed by Clinton. Kagan, appointed by Clinton. Not quite as politically liberal as these two, but pretty liberal. Stephen Breyer, appointed by Clinton. She was appointed by Obama, yeah. Kennedy, appointed by Reagan, right? And they still have not forgiven Saint Reagan for that. They adore Reagan, but they have never forgiven him. And I think the last time I was here, I think I told you about the Kennedy nomination, where classmates of mine who were working for the Attorney General, when they heard that Reagan was going to nominate Anthony Kennedy, they said, we got to run over there and stop Reagan from nominating that homo lover. Yeah, well, that's the way they think. In any event, so Kennedy, and now you have Roberts. Now you have Roberts. Not quite as much in the middle as Kennedy, but he's certainly getting there. You have Alito, and then by far the two most conservative on the courts, Gorsuch and Thomas. It's a toss-up. Who's more politically conservative? Again, that may be great. Another point. All right, one last thing for the future of the court. Future of the court. You have three that you've got to consider maybe retiring in the near future. Ruth Bader, she's 84 years of age at the end of this Trump term. She's going to be 87 years of age. She will have been on the court for 27 years. She's a liberal Democrat. If she leaves while Trump is president, you know what that's going to do to the court. It's going to solidify a politically conservative majority well into the future. Anthony Kennedy, he's going to be 84 at the end of the current term. He will have been on the court for 32 years. There's all kinds of rumblings that he's ready to retire. He apparently even told his clerks he's thinking about retiring. He's a moderate conservative Republican, but he certainly has been in the vanguard with regard to gay rights, lesbian rights, right? So if he's replaced by a Trump appointee like Gorsuch, again, that's really going to change the court. Stephen Breyer, he'll be 82, 26 years on the court. He's a liberal. If he leaves the court, same thing. It's really going to change the court for the future. These two, they ain't going. Well, actually, there's some talk about Thomas. Maybe he wants to get off the court. I mean, he will have been on the court for 29 years already. Alito, I can't imagine he's going to go anywhere anytime soon. They're young. They ain't going anywhere. And I mean, the babies. I mean, she's 50. He's a baby compared to her, right? He'll only be 52. I don't remember being 52. Anyway, and here it is. The recent retirees, the average, it's about 25 years on the court and about 82. So if the past is prologue, we could probably expect some retirements fairly shortly. I'm sure the liberal Democrats want to hang on to see if the Dems can win. All right, retirements, those are the possibilities. There it is. I mean, just think of how the court will change. Well, if Clarence Thomas retires while Trump is president, it's not going to change anything. It's not going to change anything. You may get somebody that's not as likable as Thomas, because people within the court really, really like Thomas. He's a nice man. The staff likes him. The justices like him. He's a warm, wonderful man. You may not like his votes, but they really like him. It was like Chief Justice William Rehnquist. I mean, very, very right-wing, but everybody at the court seemed to really, really like him, right? So it's not always about ideology. Ginsburg, I mean, she's really hanging on. She's hanging on. I mean, this poor woman has been terribly sick. Kennedy, again, there are rumblings. He told his clerks he may not stick around. And Breyer, he hasn't started any rumors about himself, but he's getting up there. All righty. So there you go, and I'm open for questions. Thank you so much. Thank you very much. Thank you. Yes, go ahead.
Two related. In the event Trump is impeached or an impeachment proceeding.
For what? He didn't put anything.
An impeachment proceeding is underway. Could the Supreme Court have any hand in deciding whether or not it should continue? And particularly, could Gorsuch vote on the issue of whether Trump should be impeached or not?
Great question. In fact, I was talking about that earlier today. United States versus Nixon. Let's go back a little, right? Let's go back a little. What was it, it was 73 or 74. Nixon's first appointee to the United States Supreme Court was to replace the very liberal Earl Warren with the much more conservative Warren Burger, which of course is terribly confusing. Why'd they have to have the same last name, first name, right? So it's Earl Warren going to Warren Burger, okay. And when the Watergate tapes case came to the United States Supreme Court, Nixon and his lawyers were insisting that since he is the president, he has the same kind of executive powers as the king had, and therefore he was not answerable to another branch of government. Of course, King James argued that to Sir Edward Coke, in the 1600s. But in any event, so Nixon argued that, and Nixon was counting votes on the court. Counting votes. He had appointed Rehnquist, he had appointed Powell, he had appointed Blackmun, and he had appointed Chief Justice Burger. Chief Justice Burger wrote the opinion for the United States Supreme Court, and you know what happened. Unanimously telling the president, you are answerable to the judicial branch just like everybody else is. One of the great cases, really, one of the great, not because it was Nixon, okay, I confess I voted for him twice, not because it was Nixon, but because this was the judicial branch saying, this is not a monarchy. This is a constitutional republic, and in a constitutional republic, the president has to answer to the law as well. And you have to answer to the law. You were subpoenaed to turn over the tapes. You must turn over those tapes. 16 days later, he left office, right? There's your answer. They get very, very independent when they're on the court. Very, very independent. If it's something that's not going to be too terribly big, and it's close, they don't know which way to go, maybe they'll side with the chief executive, that appointed them. On big issues, no. I remember when I was a Supreme Court fellow, and by this time, Rehnquist had become the Chief Justice. He had become the Chief Justice because of Ronald Reagan. Reagan elevated him from Associate Justice to Chief Justice. And Reagan decided that all federal employees should be randomly drug tested. So in other words, we would all have to urinate into a cup and that kind of stuff. But randomly. No, sir, no warrant, no probable cause, no reasonable suspicion. We were all subject to random urinalysis. So Reagan sends this memo around. Almost immediately thereafter, Chief Justice Rehnquist sends a memo around to all of us who are working for the judiciary, saying, you're not subject to that memorandum. This is the judicial branch. We will decide whether or not you are going to be subject to random urinalysis. They're very independent. They understand they are a separate branch. Yeah, good question. Thank you. Yes?
Has the court always been as politicized as it seems to me it's gotten more, but I don't know if it's just perception or if it's reality? And if it has become more politicized, was there a turning point? Was there a point it became so?
Right. Well, first of all, news is 24/7 now. So we know what's going on, and we hear, no matter what anybody in public office does, it's going to be covered like crazy. The fact of the matter is the Supreme Court has always been political. Those are the type of questions that come before the court. So, for example, in the early years of the Republic, the questions used to be about how much power the federal government had over commerce. Those are purely political. The Federalists wanted the federal government to have lots of power. Why? because the Federalists were in control of the federal government, right? They didn't want the states. Why? Because the states, especially the southern states, they were much more rural. They didn't want the federal government, right? So you had the Federalists and the cities, the bankers, the business people, right? And then you had the Southerners, the farmers, the rural people. Chief Justice John Marshall was a Federalist appointed by John Adams. And in his opinions, repeatedly, over and over and over and over again, he by and large remade the federal Constitution so that the federal government had a great deal of power over all business matters, over all commercial matters, as long as there was something that involved more than one state. Something. Okay. That was partisan. Federalist against the Jeffersonian. But it was also political. The court was partisan then. Throughout much of its history, throughout all of its history, it's always been political because those are the kinds of questions the court gets. What's different today, which is similar to at the beginning of the Republic, is that the court is so partisan. It's partisan. You have Republican appointees voting like Republican politicians. You have Democratic appointees voting like Democratic politicians. Why? Well, because that's what we want. Who are we kidding? People that voted for Trump wanted him to appoint somebody who was like a conservative Republican. And when we voted for Obama, we wanted him to appoint somebody who was like a liberal Democrat, right? And so that's what happens. So now you have, and this started really full tilt with Ronald Reagan, because he had a bunch of smart people, very, very partisan people who told him, you put this person on, not that person, you put this person on, not that person. Like they failed with Kennedy, right? They didn't want Kennedy, but Kennedy was Reagan's third try. It was his third try. But certainly, well, there were some inklings of it with regard to Nixon, although nothing like it is now. But with Reagan, there were all kinds of litmus tests. They tell us there's no litmus tests. You know there are litmus tests. They find out. They look at their records. They look at what they have said in public life. They look at what they have written down in law reviews, and they know, by and large, how much they can rely on these nominees, that if they're appointed, how much they can rely on them to vote like conservative Republicans or like liberal Democrats. And so that's what you have at the court now. Political, always been political. Partisan, it isn't always partisan, but it's very partisan now. I tell my students this when they ask that same question. If you look back to the 40s and the 50s, and again, I'm not talking about the good old days. I think the good old days were terrible. But the 40s and the 50s, if you look at the United States Supreme Court, you will see on one side of the court some Democrats appointees and some Republican appointees. On the other side, you will see Democrats and Republicans. You'll see them mixed up. You'll see FDR appointees arguing against each other. You'll see some Republican appointees on the liberal side and the Democrats on the conservative side. So the court was always political, but divided on partisan lines like it is now. Like the Democrats virtually always vote like Democrat politicians. Republicans almost always vote like Republican politicians. That's why I think it's just a dreadful court. Yeah.
It used to be the case that it was sort of received wisdom that presidents got justices who turned out to vote quite differently from what they had expected and anticipated. That seems to be less the case now because the vetting is so much more extreme. But the case of the Chief Justice...
Oh, no, they're only vetting them to make sure that they're qualified. Yeah, no. They're not vetting them for their positions on anything. Well, we get that nonsense.
But I'm really interested in the Chief Justice, who, in fact...
The current Chief Justice.
Yes, who does appear to be very conscious of his own legacy.
Oh, yes.
Very conscious of having a court that is perceived to be fair.
Yes.
And in the process, he seems to be moving from from his own judicial resume toward a Kennedy-esque.
His inherent partisan and political inclinations, yeah.
you say a little bit more about that?
No, most, I don't know, I haven't added them up, but many Chief Justices, if not most, are very, very concerned about their legacy. They're very, very concerned about, especially Chief Justice Roberts, about the legitimacy of the court. I mean, this is a bright guy. This is a really, really good Chief Justice. The members of the court really, really respect him. Agree with him or not, they really, really respect John Roberts. He knows what happened with Bush versus Gore, right? I mean, W gets elected because you got the Republicans voting one way and the Democrats didn't have a majority, right? I mean, come on. You know, I mean, who are we fooling? We know what went on with that thing. He's very aware of that. So, for example, with the Obamacare case, what happened? Was he going to allow his court to invalidate Obama on pure party lines? What would history say about it? Forget about what Fox News or MSNBC would say. What is history going to say a generation from now about what? About the Roberts Court, because that's what they're known. They're known by the name of the chief. It was the Rehnquist Court, right? It was the Berger Court. It was the Warren Court. And then you had a few real loser Chief Justices before that. Nobody remembers them. But yeah, so he knows in the future this is going to be the Roberts Court. He wants to make sure he leaves a legacy that he presided over a really strong court. And he's moving in that direction. It's pretty clear. He's becoming, at least incrementally, less partisan than some of the others on the court.
What are the implications of that for Citizens United?
Well, you saw, for example, in the case that we just had, right, where you had Gorsuch on the other side saying that there weren't even allowed to be restrictions on how those funds could be diverted, right, to political candidates or political committees. And the majority of the court, including the Chief Justice, right, who voted with the majority in Citizens United, right, he was in the majority to say those campaign finance restrictions were perfectly fine. I think that's certainly a signal that he doesn't intend to be as ideologically blind as some of the others. And by ideologically blind, I'm talking about the liberals as well as the conservatives on the court. Look, I would guess this is Vermont. Many of you are liberal. Some of you are probably conservative. But you know, the liberals on the court are just as blind as the conservatives. I mean, just look at Ginsburg and Sotomayor. They virtually never, if ever, see any merit on the other side. And look, I love Ruth Bader Ginsburg, but you know, dissent after dissent, it's like the apocalypse. Like, you know, the Republic is going to fold because, you know, the conservative majority, you know, won this particular case. That's not going to, you know, the Republic is not going to fold because of that, right? I mean, every once in a while there's a decision that really is a landmark, that really, really, really makes a big difference. So you can't just keep saying, you know, this is the end of our freedoms, this is the end of civil liberties as we know it. You know, she's been doing that a little bit too much. I love her to death, but I think she's been doing that a little too much. Yes, go ahead, sir.
It seems something inherently contrary to the notion of an independent judiciary to have the president appoint judges. Right? And so it's supposed to be in three separate branches of the government, but it's really 2.5 or whatever, because the president is one. And now this has become blatant, it's become extreme. So I'm wondering, is there anyone thinking about changing this is not the way it's done in all the Western democracies. Yes, I mean, if I'm not mistaken, there are several countries in the Western world where there are independent panels. It's certainly true in the country that I live in. Yes. And I'm wondering, is there any movement against this current system as there is, for example, against the Electoral College?
Well, what there is a considerable amount of advocacy that the senators ought to be doing their job. How many times do you hear from some of the senators, well, you know, I'll defer to the president? No, the president does not get to choose whether or not a particular nominee gets to sit on the United States Supreme Court. The president gets to nominate. And that nominee only gets to the United States Supreme Court when the senators confirm. And the fact of the matter is, which is the truth of what you're saying, is that the senators don't do their job. Why don't they do their job? If you have a president with a very strong base, like Trump does, they probably don't want to cross him, right? Or if you have a president who is very popular, right, like a Bill Clinton or a Barack Obama, you probably don't want to be voting against him either, right? So you may or may not think his nominee is particularly good, right? But as a politician, you're thinking about your next election. And also, I think there's a great deal of misunderstanding, if not total ignorance, about the role that the Senate is supposed to play in the appointment of Supreme Court justices. The appointment process is 2 steps. It's not 1 step and then you defer to the president. It's 2 steps. The president nominates, the Senate must give the okay. That's not the way we do it most of the time. Although, you know, about between a fourth and a third of the nominees have been rejected. So there are times, like what the Senate did with regard to Robert Bork, but he was hardly the only one. With regard to Robert Bork, I mean, that poor fellow, and when I was down in Washington, D.C., I got to know him a little. I also got to know that he was widely respected, if not admired, agree with him or not. People really liked this man. But he was honest. He came before the Senate Judiciary Committee and he told them what he believed. And the fact of the matter is, if nominees actually told the Senate and that got on the news what they really believe, I mean, from a real legal point of view, like this is really what the Constitution means, the public isn't going to like it. And so the senators aren't going to like it. And that's what happened with Bork, right? Most of them, you know, were for Bork. Very, very, very well qualified, right? But as soon as they start finding out about his votes, which were honestly cast, because that's what he thought the Constitution meant, right? As soon as they start finding out about that, and Ted Kennedy start telling everybody what the ramifications of those votes were, correct or not, right? Public didn't like him too much. And then, of course, the senators just caved. And so Bork was rejected. That's what happened.
Doing what you suggest they should be doing.
Well, I don't think the senators ought to be listening to the ignorance of the people, right? But, you know, if the senators said, I don't want to vote for somebody who is against a woman's right to choose, that's one thing. That's one thing. But if they start saying, I'm not going to vote for him because, you know, that one opinion he wrote about some workplace issue, about which he was probably right, but isn't very popular, right? But isn't very popular, and so my constituents don't like it, I'm going to vote against him. I mean, that's just cowardice. And you saw a lot of that with regard to Bork. Right? I mean, look what happened to the subsequent nominee, right? So Bork blows up in Reagan's face. And then, so Jim Baker, chief of staff, says to Reagan, okay, you ought to nominate this guy, Anthony Kennedy from Sacramento. He's going to fly through. He's very, very popular. He's not offensive to anybody, right? Good judge. So Reagan calls him in. The guy flies in from Sacramento. And that's when my schoolmates with Attorney General Meese rush over to the White House and say, you can't nominate this guy because he's a homo lover, right? So what does Reagan do? At the press conference, which had already been scheduled, instead of showing up with Anthony Kennedy, he shows up with Doug Ginsburg. You know what happened with Doug Ginsburg? They found out that he smoked marijuana with his students, which apparently is worse than just about any crime there is to certain conservative Republicans. So they made him withdraw immediately. At this point, Reagan was so upset with the right-wingers in his inner circle, he said, I'm going with Anthony Kennedy. And of course, Anthony Kennedy flew in, right? Yeah. Yes?
What does it mean to reverse a decision? We're hearing about reversing Roe v. Wade, reversing Citizens United. How are we going to do that?
Well, the United States Supreme Court has reversed lots of cases. In fact, Then when I went through all the landmarks, all those landmarks were reversals. You like right to counsel? That was overruling precedent. You like double jeopardy protection? That was overruling. You like free exercise of religion? That was overruling a bunch of cases. Just about anything. Just about equal protection for women. Women under the law are entitled to equal rights. You like that one? That overruled a whole slew of decisions by the United States Supreme Court. So what happens? What happens after a while, and usually it is after a while, you will get states, and you can imagine which ones they are, that are usually out in front, right? So you'll get a New York, you'll get a California, you'll get a Vermont, and you'll get a Washington and Oregon. And those states, either by judicial decision or by legislation, will start protecting what they think to be civil rights or civil liberties, or they think to be protections against corruption or whatever. They start doing this. So after a while, it's not too radical. After a while, it's not too radical. When it's not too radical, after it's been percolating now within the states and maybe in some of the federal courts, that's usually when the United States Supreme Court will be willing to take the case. Until then, it doesn't like to take the case. It doesn't like to expend judicial capital, right, as the nation's highest court, to be doing something that's radical. You said Roe versus Wade. You may like the right to choose. I certainly like the right to choose, but Roe versus Wade is a terrible decision. It's an absolutely dreadful decision. I mean, there's no lawyer who objectively would look at that opinion and think it's a good opinion. Do I think there should be a right to choose? Yes, but not the way the court did it. Not the way the court did it. Instead of simply saying that the laws of, the usual suspects, Texas and the rest of them, the laws of those states would absolutely ban any kind of abortion, rape, anything, banned anything. Instead of just simply saying that the government does not have a legitimate interest in an absolute ban against abortion, right? If the states can if the states can come up with some compelling reasons in particular circumstances for prohibiting abortion, that might have merit and get through. But with regard to absolute bans, no, there's no legitimate government purpose for that. They could have done that. Instead, what'd they do? The court and the country was not ready for it at all. In fact, virtually every single state, if not every state, had lots of restrictions on abortions. Even very liberal states had lots of restrictions on abortions. The United States Supreme Court in Roe versus Wade not only said absolute bans are no good, the court went through this first trimester, second trimester, third trimester. I mean, like they wrote legislation. It was bad legislation. So, even liberal scholars will tell you that Roe versus Wade is not a good opinion. And what has happened because it's not a good opinion? It just keeps getting whittled away. Whittled away and whittled away and whittled away because it's really weak. It's really weak. Yeah. Okay.
Thank you very much.
Oh, thank you. Thank you so much. Thank you. Thank you. You guys are great.